Welcome, welcome everyone. Welcome to Summerview Community Church and to our next installment of our Ecclesia Forum this evening. So glad that each and every one of you were able to be here this evening. My name is Josiah Arikaios, if I don't know you, and I'm going to introduce our guest and have him come up here, and we'll get started right away. Retired Professor Robert G. Natelson is the Independent Institute's Constitutional Studies Center head. He is a nationally known constitutional scholar and author whose constitutional research has been cited repeatedly by justices and parties at the U.S. Supreme Court, as well as by federal appeals courts and at least 16 state Supreme Courts. Rob is widely acknowledged to be the country's leading scholar on the Constitution's amendment procedure. He created the first ever online bibliography for 18th century materials used in constitutional research. His research into the Constitution's original meaning has carried him to libraries throughout the United States and in Britain, including 4 months at Oxford University. Since 2013, Rob has become one of the most cited constitutional scholars by U.S. Supreme Court justices. They have relied explicitly on his research in 39 citations in 11 separate cases. He is a principal author of several Supreme Court briefs submitted by the Independence Institute and other organizations to the U.S. Supreme Court, the U.S. Court of Appeals for the 10th Circuit, and the Colorado and Montana Supreme Courts. Without further ado, please help me welcome Rob Natelson.
Can you hear me? You sure? Okay. Thank you very much for inviting me. This is a real privilege to be with you today, talking about my favorite topic, next to my wife, Betty, the U.S. Constitution. It seems, doesn't it, that there's always something in the news about the U.S. Constitution. Right now, it is the dispute over whether former President Trump can or should be disqualified from running for president again. There are a host of issues in that particular case. Lawsuits have been filed all over the country trying to disqualify the former president. Generally, those lawsuits have not been successful judicially, except in one state, this one, in which a 4-3 majority of the Colorado Supreme Court held that the former president was in fact disqualified for future service. We'll talk a little bit about those issues that are involved later on after I get through my main presentation. Let me just say that the issues in the disqualification case are particularly difficult because they involve the 14th Amendment. The 14th Amendment was proposed by Congress right after the Civil War in 1866, and then it was ratified by the adequate number of states in 1868. Unfortunately, while the 14th Amendment had some really good purposes, its purpose was to prevent the states from oppressing racial and other minorities. It had a good purpose. In fact, the drafting of the 14th Amendment is not that good. And as a result of that, there's been an enormous amount of controversy ever since the amendment was passed over the meaning of certain terms. And now we see this playing out again with the Trump disqualification lawsuits under Section 3 of the 14th Amendment. So I will come back to that. Generally speaking, the Constitution does not involve the kinds of lack of certainty or indefiniteness that the 14th Amendment suffers. Generally speaking, the people who wrote the Constitution knew what they were doing. The 55 men who gathered in Philadelphia in 1787, by the way, it was not a hot summer. You ever heard anybody say that? It's a long, hot summer in Philadelphia. We actually had the temperature readings, and it was a relatively cool summer. There were some hot days, but it was a relatively cool summer. I just mentioned that as an aside. Anyway, the people who got together in that relatively cool summer of 1787 were highly accomplished drafters who had experience in drafting other constitutions, state constitutions, the Articles of Confederation, and other kinds of legal documents of the same general kind. So the kinds of uncertainties that exist with the 14th Amendment, for the most part, don't exist with the original Constitution. And so when you hear someone say, well, the Constitution is vague, we really don't know what it means, the court can make it mean anything it wants, be assured that that's really not true. Now, there are, as you know, a lot of people who not only think the original Constitution is vague, but they also think that we should give up on it, including some law professors. The original Constitution is out of date, they say, or the original Constitution was designed to perpetuate slavery or oppress women or maintain an unjust economic system or whatever. Especially in the commanding heights of our economy, there are people who think that way. People who think that way in the media, in academia, in foundations, in big government, in big business. I've been working with the U.S. Constitution on a daily basis now for almost 35 years. And I bring to it not just an academic understanding of the Constitution. I've also practiced as a lawyer, and I've run my own business, and I've served in government. I think I've got a pretty wide range of experience. And I've concluded that it would be a big mistake to abandon the Constitution. That, in fact, the Constitution has been an enormous gift to the American people, and to the extent it continues to be in force, it continues to be a gift to the American people. We often take that for granted. So I'm going to submit to you 5 reasons why I think this document is so important and remains so invaluable today. The first reason, and I'm going to summarize them first, and then we can go through them in detail. The first reason is the Constitution has, with the exception of one short period of time, assured peace among the states, peace in the United States. Secondly, the Constitution, by limiting the authority of the federal government, has enabled people to thrive, has created the most prosperous country in the history of the world, and enabled a period of enormous human progress. Thirdly, the Constitution's Bill of Rights and other protections for liberty remain an important component in protecting freedom. Fourth, this is a little more subtle, the Constitution represents a judicious balance of interests. The value, you know, of there's a value called prudence. The terms of the Constitution are shot through with the value of prudence. And then fifth, the Constitution has an amendment process by which we can respond to new circumstances and make changes when we have to. So let's look at each of those 5 elements, starting with the way the Constitution has preserved peace. We take this for granted. We had 4 years of civil war, but we've had 233 years of peace among the states. Let me take you back to 1787. In 1787, the United States was held together by a loose treaty organization. Anybody know what it was called? The Articles of Confederation. It was a treaty organization like NATO is today. A treaty among 13 sovereign governments. And the treaty organization was beginning to break down. Hostility arose among states over various causes. The states of Rhode Island and Connecticut actually almost came to blows because a lot of Rhode Island debtors owed money to Connecticut creditors. Connecticut creditors wanted to be paid. The Rhode Island debtors didn't want to be paid, and each group got its own legislature to pass retaliatory legislation against the other. The founders also were aware that because of Europe's political fragmentation, Europe had gone over the past 150 years through horrible wars. In the 150 years before our Constitution was adopted, there were no fewer than 70, that's 70 wars fought in Europe. And that doesn't count rebellions. One of those wars, the 100-Year War, is estimated to have cost about 8 million lives on a much lower population base. The War of the Spanish Succession, fought early in the 1700s, cost about 500,000 casualties. The 7 Years' War, which in this country we call the French and Indian War, was another international conflict among states in Europe. It cost about 1 million lives. A recurring nightmare that the founders faced was the possibility that war could break out among American states and that could be aggravated by foreign intervention on one side or another. So that if Maryland went to war with Virginia, France might intervene on behalf of Maryland, Britain on behalf of Virginia, thereby aggravating the situation and duplicating the kind of bloodshed that had afflicted Europe for the previous 150 years. Many people wonder, well, were the founders pro-slavery? Well, no, most of the founders were anti-slavery. Well, why didn't they just abolish it? Because they recognized that if they did abolish it, some states wouldn't join the Union, specifically Georgia and South Carolina, and we would be facing a fragmented continent with a potential for warfare. And of course, in any situation like that, the people at the bottom of the political ladder, of the economic ladder, that is to say the slaves, would suffer the most. So the compromises that were made with slavery, like other compromises in the Constitution, were designed to at least accomplish the purpose of establishing peace. And the Constitution worked in that respect. So that's one of the great contributions of the document, and one we, I think, take for granted. Let's go to the next one. The founders understood that while they needed a central government that was strong enough to keep the peace, they should not have a central government that was strong enough to do anything it wanted. That when you're dealing with a country which even in 1787 was absolutely huge, you have to take into account the fact that there are local preferences, that there are different cultures throughout the country, that there are different conditions throughout the country. And so establishing one centralized government, like, say, that of Great Britain, throughout the entire United States, was impractical and foolish. and also might create a real danger to liberty. Because if one central power became strong enough, it could oppress the people generally and would suffer no real check from local governments. And so the second great contribution of the Constitution was the idea of federalism. The idea that sovereignty is ultimately in the people, but the people don't give their sovereign powers just to the central government or just to the states. What the people do is they split those sovereign powers. They give some to the central government and some to the states, and create a system whereby the central government and the states actively check each other. The central government was set up to handle issues like national defense, foreign relations, the regulation of commerce, running the post office, but the vast majority of decisions in human life were to be left with the states, with localities, with private organizations, with businesses, with churches, with families. Most decisions were not to be made by the central government. That is the second great contribution that the Constitution gave to us, this idea of federalism, what former U.S. Supreme Court Justice Anthony Kennedy used to call splitting the atom of sovereignty, splitting the atom of sovereignty between the federal government and the states. Was this successful? Well, generally, yes. Think back when you were in school, or maybe those of you who are in school, think about things today. Think about the civilizations that you're aware of that have been responsible for the most explosive eras of human progress. Think, for example, of ancient Greece with the quickening of the American mind, or the early Roman Empire, the rule of law, the rise in living standards, or Renaissance Italy with the explosion of arts and culture, or Renaissance Germany, or even 18th century England with the beginning of the Industrial Revolution. What do all those societies have in common? What all of those societies have in common is political decentralization. Political decentralization. In fact, in the case of Greece and Italy, they're so decentralized that there wasn't even a power that could prevent war. But political decentralization creates an environment in which people can move from one area to another. If they don't have opportunity in one state or one city, they can move to another. If they get crosswise with the politicians located in one part of the country, they can move to another part of the country. And individual parts of this area actually compete against each other for talent. So Galileo gets kicked out of Florence, no problem. He goes to Padua, right? Aristotle doesn't get what he wants in Athens, no problem. He goes to Asia Minor. There has been a strong association between that kind of decentralization and political progress. And you see that also in 19th century America, when our government was, in fact, more decentralized than it is now. It's in 19th century America and also in decentralized Europe that we invented the telegraph, invented the telephone, the television. We invented the railroads. We freed the slaves. We liberated women. We had enormous progress beyond what we've ever seen before, largely as a product of that decentralization. That's one of the gifts that the Constitution has given us. Third, the Constitution's specific protections for liberty. Most of the framers of the Constitution did not think a Bill of Rights was necessary. Anybody ever hear that? They did not think a Bill of Rights was necessary for technical legal reasons. But there was a guy in Virginia who had a different view. His name was Patrick Henry. And Patrick Henry said, look, you might not think a Bill of Rights is necessary because you think the document can be interpreted to protect freedom of speech or freedom of religion. But the reality is that the average person wants a Bill of Rights. The average person wants it down in writing, right? Wants to be able to look at a list and recognize the rights to which he or she is entitled. And therefore, under the leadership of people like Patrick Henry, a deal was cut whereby the Constitution was ratified, but the advocates of the Constitution agreed that Congress could propose and the states would ratify a Bill of Rights. Every day it seems that there's some new threat to liberty, which makes me grateful anyway, that we have a Bill of Rights. Isn't always perfectly enforced, as you know, but we're a lot better off with it than without it. That also is one of the gifts of the Constitution. The fourth gift is this judicious balancing of interests, this thing about prudence I mentioned. When you were in high school, you may have heard about something called the Great Compromise. The Great Compromise, as it's usually branded, is, well, the Congress is divided into two chambers, two houses, and the Senate represents the states. Every state gets 2 senators, right? But the House of Representatives is chosen mostly, not entirely, but mostly on population. Well, the Great Compromise was important, but it is in fact only one of many, many compromises in the Constitution. In fact, I'm not even sure it's the greatest compromise. The greatest compromise might be federalism, you know, splitting the difference between an all-powerful federal government and all-powerful states. But all through the document, there are compromises. Think, for example, of the terms of office. 2 years for the House of Representatives, 4 years for the president, 6 years for the senators. That was compromise. Or think of what's called the origination clause, which says that if you're going to have a tax bill, a bill to impose a tax, the bill has to originate in the House of Representatives. It can't be introduced first in the Senate. That was a compromise. Or think of the Electoral College. The whole presidential election system, in fact, not just the Electoral College. That's a whole series of compromises designed to take into consideration and to balance about 12 different factors that the founders had to consider in deciding how to elect the president. So there is, all through the document, a series of these judicious compromises. And they weren't just adopted as a result of the pull and push of politics either. It wasn't just a matter of, I'm from a big state and therefore I want big states to have more power. Well, I'm from a small state and I want small. It wasn't just that. Many of these compromises were based upon a careful reading of history and precedent. The founders investigated what had worked in previous governments, what hadn't worked in previous governments, and worked their way through to a long series of judicious decisions. And then I'm going to focus on one particular example of a compromise, and that was the one on religion. I think the surroundings make it appropriate. What would be the posture of the new federal government toward religion? There were two polar positions that the founders could have adopted. In other words, there were two extremes. One possibility was to adopt what some commentators have called the godless Constitution. In other words, we'll adopt a Constitution which is wholly secular in nature. We'll have a government which is wholly secular in nature, like the French Revolutionary government adopted just a few years later. That's one possibility. The possibility on the other side would be to have a state religion, a national religion, presumably some branch of Christianity. That was certainly a reasonable possibility because whatever you may have heard about the founders, the overwhelming majority of them were Christians. They were not deists. And the states, virtually all the states, had some kind, Rhode Island accepted, they all had some kind of state religion in one form or another. So that might have been an option too. What the founders did is they compromised. While the Constitutional Convention was going on, a man named Jonah Phillips, who was a leader of the Jewish congregation in Philadelphia, wrote a letter to the president of the Constitutional Convention, George Washington. And he said, you know, we Jews have been very loyal Americans. We virtually universally sided with the American Revolution against the British. We fought in the American Revolution. We helped to finance the American Revolution. But we can't serve in political office in hardly any state but Rhode Island because we don't agree to the divine inspiration of the New Testament. So when you write the Constitution, would you please allow people of any faith to serve in office? And the delegates apparently took that seriously because they put in the Constitution a provision that there would be no religious test. Well, did that make it a godless Constitution? No, it didn't. Because they also put into the Constitution a provision which says that anyone who takes up a federal or state office must pledge an oath. And in the 18th century, only believers in God were legally entitled to take oaths. In other words, what the founders did is they established not a godless constitution, not a purely Christian constitution, but a theistic constitution, one in which the God of all would be the God of all citizens. Very judicious compromise, worked very well. When the Constitution came up for ratification, the way it was approved was that each state held elections and chose a convention to decide whether to approve the Constitution or not. During the ratification conventions of some states, some opponents to the document stood up and said, we can't approve this document because we could have Jews elected to office. We could have Muslims elected to office. We could have deists elected to office. There's got to be a requirement here that all office holders and all voters be Christians. And the supporters of the Constitution met that objection head on and said, no, there are good men of every religion, and they all should be permitted to serve. And it was on that basis that the Constitution was ratified. A very judicious compromise. The last of the 5 advantages that I should mention is the amendment process. It's kind of hard to believe but many of the constitutional style documents that had been adopted previous to the U.S. Constitution did not provide for amendment. I'll give you one example. In 1776, the state of South Carolina adopted a constitution. That's in 1776. State of South Carolina adopts a constitution. 2 years later, in 1778, they decided there were some things wrong with this document, but there was no way to amend it. So they had to adopt an entire new constitution. Similarly, the Articles of Confederation were theoretically amendable, but in order to amend it, you had to have the approval of all 13 states. So as a practical matter, it was not amendable. The founders decided to include an amendment process, and they did so for 4 reasons. Number one, the founders were very great men, but they were not gods. And they knew they were fallible. They knew they might make mistakes. They recognized that there might be something in the Constitution which they overlooked or was a mistake that needed to be changed through an amendment process. And boy, were they right, because when they drafted the Constitution, they included a set of qualifications for the president. They included a set of qualifications for senators and for representatives, but they didn't include any qualifications for office for the vice president. Why? They forgot. And so in 1804, they adopted the 12th Amendment, which established that the qualifications for the vice president are the same as for the president. They recognized, in other words, despite part of their greatness was they recognized their own fallibility. Secondly, they recognized that the Constitution is first and foremost a legal document. It is, to quote, the supreme law of the land. Well, how is law applied? Generally, law has to be interpreted. Do lawyers always agree on how a document should be interpreted? No. Are the courts always right about how a document should be interpreted? No. And so one of the purposes of the amendment process was to allow the people, if they thought the document needed to be cleared up or they needed to overrule a Supreme Court decision, to allow the people to adopt amendments to clarify things. And again, the founding generation did that. In 1793, the U.S. Supreme Court issued a wrong decision. The founding generation immediately responded, passed the 11th Amendment, and reversed that decision. Then, in addition to that, the founders lived 1787. The Industrial Revolution had already begun. Enormous change was going on. As a general, George Washington must have scratched his head and seen the first balloons go up, the first hot air balloons, and wonder about the military options that could be performed from balloons. In other words, they knew that technology was changing, and they recognized it might be necessary to change the Constitution to reflect the technology. And so that's another reason why they adopted an amendment process. In fact, the 20th Amendment, which shortened the period between the time a president is elected and the time he's sworn in, was adopted as a result of technological change. You know, by the time of the 20th Amendment in 1933, we had airplanes and we had trains and we had cars, and people could get to Washington, D.C. a lot faster, and so we could have an earlier inauguration date. And then finally, what I think is probably most relevant today about the amendment process in terms of a reason is the amendment process was designed as a way that people could respond to government abuse or government dysfunction. When you read the polls tell you that something like, when people are asked, do you approve of the job that Congress is doing? Something like 6% of the people say yes. Now, I'm not sure who these 6% are, because I've never met him. But there is very, very wide dissatisfaction with the way Washington, D.C. is working. And if we were to bring back James Madison or John Dickinson or John Adams today, they would say, well, to respond to that kind of abuse or dysfunction, it's not going to be enough to elect good people if the system isn't working. What you need to do is you need to amend the Constitution to correct things. They put a provision in the Constitution, in particular, that allows states, 2/3 of the states, to force Congress to call a meeting. Meeting is called a convention. Convention for proposing amendments. The idea is to empower the people through the state legislatures to bring about this convention, this meeting of representatives from the states, to assess the situation and to recommend constitutional amendments. This was supposed to be a major check and balance in the Constitution. You know, we have checks and balances in the Constitution, like the president gets to veto bills, the court gets to declare laws unconstitutional, the Congress gets to impeach the president and other executive officers. We have these checks and balances. And yet one of the checks and balances that the founders thought was the most important of all, the ability of states to call a convention for proposing amendments, has never, ever been exercised. And that sort of explains the reasons why the system doesn't seem to be working very well at this point. So it's for these reasons that I think the Constitution is worth keeping, and I believe it's worth defending. I do believe it's worth considering amendments as well. But you don't throw the baby out with the bathwater. You don't reject the document because there are individual problems with it. I think before quitting and taking questions, I should say something about the Trump disqualification lawsuits, just to familiarize you with some of the issues. There is a flyer or a single page passed around in which I've reproduced Section 3 of the 14th Amendment. I mentioned going in that the 14th Amendment is not a particularly well-drafted piece of work. And so there are a lot of questions that have arisen regarding it. Essentially what Section 3 says is that if someone takes an oath as an officer of the United States, then engages in insurrection, that he becomes ineligible to become an officer under the United States. Now, President Trump took an oath when he became president on January 20, 2017. He took an oath as president. A president is clearly an officer, right? But the 14th Amendment doesn't say just officer. The 14th Amendment says he must have taken an oath as an officer of the United States. And there's a substantial amount of history, and there's evidence from the Constitution's text that the term officer of the United States refers only to appointed officials. It does not refer to the president, vice president, senators, representatives. And so the argument that President Trump is making, one of his arguments, is that because he did not take an oath as an officer of the United States, he's not subject to the disqualification. The Colorado trial court accepted that argument. So this argument sounds a little strange until you read the history and you read the way the term officer of the United States is used in the Constitution. Now, former President Trump is seeking the presidency again. He is seeking the presidency. Again, the presidency is an office. But he can only be disqualified if the presidency is an office under the United States. Different preposition this time. This term is very old. It comes from Britain, where they used to refer to officers under the crown. And again, President Trump's argument is that an officer under the United States is an appointed officer, not the president. So the disqualification clause doesn't include the president. And by the way, there are all kinds of arguments to buttress that. It's not just all technicalities. The trial court also adopted that position, that the presidency is not an office under the United States. The third issue is what the definition of insurrection is, and related to that, whether President Trump's activities on January 6th or leading up to January 6th actually comprised insurrection. It's another issue. The next one, you'll see on the sheet of paper, there's a section 5 in the 14th Amendment. The Congress shall have power to enforce by appropriate legislation the provisions of this article. In other words, Congress can pass laws to carry this out. One of the arguments the former president has raised is that the disqualification provision requires that a law actually be passed by Congress first. President Trump has never been convicted of insurrection. President Trump has never even been charged with insurrection. And so if you want to disqualify him, there's got to be some procedure specified by Congress. During the oral argument over this case, Justice Elena Kagan, one of the more liberal members of the court, glommed onto this argument. She seems to like that argument. She seems to believe that it would be required for Congress to pass a law in order to use this disqualification section. I'm not sure I agree with her on that point, but that's her position. And then the final one, which is an interesting question, which I do not know if it's going to be even mentioned by the Supreme Court justices, is the question of due process. The 14th Amendment also requires that every state, before it punishes somebody, grant that person due process of law. Was former President Trump granted due process by the Colorado trial court that decided that he was guilty of insurrection? My own view, no, I don't think he was. And the reason I say that is because a lot of what the trial court recognized, relied upon, was hearsay. What do I mean by that? I mean the trial court relied very heavily upon the report of the January 6th House of Representatives Committee. And that report was hearsay, and that report was generated under circumstances where President Trump was not allowed to be present, not allowed to have counsel, not allowed to introduce evidence, not allowed to cross-examine. The 3 dissenting justices of the Colorado Supreme Court basically agree with me on that point, that there simply was not adequate due process to impose the punishment of disqualification. So that's kind of a thumbnail of the issues. We'll see what the Supreme Court does with it. And I would like to see if you have any questions. None? Thank you very much. Yes, sir. Oh.
Thank you so much. Yeah, thank you so much. My goodness, what a privilege hearing all your thoughts. Just in regard to the point you're just now addressing on the Colorado Supreme Court, first question on that: Are they serving terms, or are they for life? I don't know.
8 years.
8 years. Do you think that their decision could be in any way reflected to the fact that their constituency then is a very liberal state, and maybe they, vote to, try to appease the state they serve? I don't know. Do you have any thoughts?
I'm going to give more credit than that. You know, the Colorado Supreme Court does tend to be liberal, and many people have pointed out that all the justices were appointed by Democratic governors. But on the other hand, and I often have quarrels with the Colorado Supreme Court, but I think they took their duties very seriously in this instance. My own view is that they were insufficiently critical of the January 6th House of Representatives report. But otherwise, I thought that they were pretty thoughtful. Yes, ma'am. You get a microphone.
Thank you. So my question is, Colorado was kind of leading the way as to whether or not Donald J. Trump will even be on the November ballot, because Maine and other states are trying to follow Colorado's lead. What are your thoughts on that?
Well, my view right from the beginning is that the disqualification actions are going nowhere. There simply are too many obstacles to them. In some states, they've been rejected because of lack of standing. Some jurists take the position, as Justice Kagan seems to, that you need a federal law on the subject. There are the questions as to whether the presidency is an office of the United States or under the United States. There's a question as to whether, whatever you think about the former president's actions, he did give a speech in which he told his followers to proceed peacefully and patriotically. And I think that's kind of hard to make insurrection out of that. So I don't think ultimately it's going to get too far. And in fact, the Colorado Supreme Court is the only judicial victory that the advocates of disqualification have had. And based upon the questions from the justices, including the liberal justices, during oral argument, I would be surprised if Trump doesn't win this one by 8-1 anyway. Yeah.
Can I follow up?
Yeah.
So Congress has actually passed a thing saying that that they don't believe that insurrection. Matt Gaetz introduced the bill into the House a couple weeks ago to say that they don't believe that insurrection was committed. And then, so I'm not quite sure how that might play into it. Plus the whole idea that we, the people, are supposed to be electing our president, not the judicial system.
Yeah. The counter to that is that a majority of members of the House of Representatives voted to impeach Trump for insurrection, and a majority of the Senate, although not the necessary 2/3, a majority of the Senate voted to convict him. So the counter to that is that actually a majority of members of Congress have determined that he engaged in insurrection. But you also have, as you suggest, the democracy problem. You know, we the people are supposed to be electing our president, not the judges. One of the arguments, I mentioned this argument about officer of the United States, officer under the United States. It's not merely a technical argument. One of the arguments in favor of reading this language restrictively, so the president is not included, is that if the people are really the highest authority on whether they're going to forgive somebody for something, right? And so it may very well have, we don't have proof of this, but it may very well have been the feeling of those who drafted and ratified the 14th Amendment that we're not going to extend this to the president, because if the entire American people decide that this person is to be forgiven, if there's a need to forgive, then we don't want to stand in the way of that. So I'll just leave it at that.
What, if any, are the reasons why the states have not held the amendment conventions? Have they been stopped? Have they tried doing it? Or have they just never tried or not had a reason to?
That's a really good question. Remember earlier I was talking about this procedure in the Constitution whereby the states can call a meeting called a convention for proposing amendments, and they can propose amendments. What I didn't say is the convention only proposes amendments, it doesn't ratify them. So they still got to go to the states and be approved by 38 states, to 3/4. Why hasn't such a convention been held? Until about 50 years ago, the reason why a convention had not been held is because whenever it looked like we were going to have a convention, Congress responded by proposing the amendment itself. One reason we have a Bill of Rights is that in 1788, after approving the Constitution, Virginia applied for an amendments convention. And then New York applied for an amendments convention to get a Bill of Rights. And so when James Madison stood up on June 8th, 1789, to introduce his Bill of Rights in Congress, one of the arguments he made was, if we in Congress don't propose a Bill of Rights, the states will do it for us. And so it was not necessary to hold a convention because Congress proposed a bill, which the states then ratified. Fast forward to the early years of the 20th century. Originally, United States senators were chosen by state legislatures. This system began to break down late in the 19th century for reasons we can explain. And a very popular idea arose. That idea arose of having the people elect U.S. senators. The states started circulating what are called applications for a convention. They needed 32 states, 32 out of 48 states to force a convention. And just when they got almost enough states to force the convention, Congress went ahead and proposed the 17th Amendment itself. Then fast forward to the 1940s, 1950s, President Franklin Roosevelt had violated the two-term tradition by running for a third term, then a fourth term. And so many people started arguing we need to put a two-term limit in the Constitution. And so once again, the states started basically the process of applying for a convention. But before it had gotten too far, Congress went ahead and recommended the 22nd Amendment, adopted finally in 1951. So for the first 180 years, the reason we did not have a convention is because when a proposed constitutional amendment became popular enough for there to be a convention, Congress proposed it itself. For the past 50 years or so, the situation has been different. Beginning in the 20th century, opponents of a convention started what might be called the constitutional convention myth. This is the idea that if we hold a convention to propose amendments to the Constitution, it could be a constitutional convention that could essentially do a coup d'etat, essentially take over the government, or change the Constitution any way it wanted, or rewrite the Constitution any way it wanted. Now, this is in fact not true. It is absolutely not true. But that particular line has been picked up by a lot of people who oppose a convention, by people who favor the status quo, by people in academia, by people in government. And so there's still a situation is a lot different than it was, say, 10 years ago. But there still is a belief in a lot of quarters that, gee, if we held a an amendments convention, it could be a constitutional convention, and it could rewrite the entire government. And that is usually enough, or often enough, to stop a state from applying for a convention. Although 19 states have in fact applied for a convention.
So I have a quick question about the state of Colorado, and then I have a couple of just devil advocate questions
Sure.
about the history of the 14th Amendment. So my question about the state of Colorado is, if I remember correctly, didn't the state of Colorado, by a House bill, not by putting it to a vote to all of us, enter into a multi-state compact where we were going to give our electoral votes to whoever was the winner of the popular vote? Okay, so if that is the case, we just haven't happened to go into that compact because there are not enough states who have joined into the compact at this point. But if that is our intention, then how can we also be leaving one of the candidates off of the ballot? Is that not a conflict of interest?
What she's referring to is a proposed interstate compact called the National Popular Vote Compact, whereby every state that signed on to the National Popular Vote Compact would give its electoral vote to whomever won a plurality of the popular vote in the presidential election. So if candidate A won 40% of the vote, candidate B won 39% of the vote, and candidate C won what's left, 21% of the vote, then no matter how the voters of the state voted, no matter how the voters of Colorado voted, under the compact, all of our votes would go to the plurality winner. We did, in fact, the legislature did, in fact, approve that compact. People had an opportunity to reverse it. The people decided by a narrow margin not to reverse it. As a practical matter, the compact is not constitutional.
Exactly.
There are multiple problems with it. If you're curious, you can go to the Independence Institute website. I wrote a series of articles indicating the constitutional problems with it.
But so isn't the state of Colorado, though, undermining its own arguments, though, with this conflict of interest?
Well, the state of Colorado didn't bring the lawsuit. The lawsuit was brought
Okay.
by 6 independent and Republican voters. And the Colorado Supreme Court made a decision based on its interpretation of the law. So it's not exactly like the state legislature is contradicting itself in that way.
Okay. All right. And then just a couple of odd little questions about the history of the amendment. So you were saying that Donald Trump had used the argument that he took an oath not under the law, but
He
that
took an oath as an officer, but not as an officer of the United States.
and not appointed.
Yeah.
But wasn't that amendment written for Jefferson Davis, and wasn't Jefferson Davis elected as a senator, first of all? And then, well, I'll just leave it at that for now.
Okay. If you look at the wording,
Okay.
it refers to as a member of Congress or as an officer of the United States. So Jefferson Davis was in fact a senator,
Okay.
and he took an oath, and he violated the oath. Jefferson Davis, under this particular language, could not be elected to a state office, could not be elected to the Congress, but presumably he could be elected to the presidency.
Oh, that's interesting.
Yeah, because again, the presidency would not be an office under the United States. Well, you might say, well, why would they exempt the presidency? And the answer, I think, was pointed out by one of the more liberal justices, Ketanji Brown Jackson, in which he said the focus of the drafters of the 14th Amendment was on the risk that individual states would be taken over by insurrectionists. That a state like Florida, for example, which had been in Confederacy, could become essentially an insurrectionary state again. They were not that concerned about Jefferson Davis being elected president of the United
President of the
States.
United States. Okay, and then the other thing you mentioned was that Congress would have to pass a law, but the law would have to be passed after the acts were actually committed. So how could it retroactively hold them responsible under the law?
Well, that's a very good question. It wouldn't necessarily have to be passed after. I mean, they can pass a law, and then someone later commits insurrection, and you follow the legal procedures.
So you would have to anticipate
Yeah.
lots of different forms
Right,
of
you'd have to
insurrection.
anticipate it. Now,
Which hasn't been done.
You do, I agree, if you passed a law today and then tried to apply it to President Trump, you've got a retroactive activity problem, right?
Exactly.
Yeah, and so that's a difficulty there. My own view is I don't think a federal law is necessary. I think a federal law is maybe permissible under Section 5, but I think a state can disqualify somebody for being an insurrectionist, but I would argue that that person has to have taken an oath as an officer under the United States, has to be disqualified for an office, has to have taken an oath as an officer of the United States, has to be disqualified from an office under the United States, and has to be granted due process. I can't hear you.
Does that work out to being about the number of family and friends that they actually have?
I wouldn't know. Yes, sir. Well, let's give you the mic.
Interesting stuff. Thomas Jefferson versus Jefferson Davis, I guess. And ex post facto laws. Anyway, I have a question. We mentioned the Bill of Rights, the 10 first ones. Wasn't there another 10 that were sort of proposed over the next 10 or so years? And I was thinking about particularly number 27. It went 200 years, and then suddenly they passed the thing, and it became the 27th Amendment. Do we have any other amendments like that floating around out there that after 200 years they could suddenly be the 28th Amendment?
Oh, yeah. The Bill of Rights originally had 12 amendments. The First Amendment would have expanded the size of the House of Representatives. The Second Amendment prohibited raising congressional pay until an election had intervened. So in other words, you vote a pay raise, but then you allow the people to vote before the pay raise takes effect. That original Second Amendment, as you accurately suggest, became the 27th Amendment, and became the 27th Amendment when it was finally ratified by the 38th state in 1992. The original First Amendment, the one to expand the size of the House of Representatives, never became part of the Constitution. Could it still be ratified today? In theory, I think it probably could be. It would result in our having a House of Representatives under its terms of about 6,000 members. Maybe that'd be better than what we have today. I don't know. I can't think. Let me think a second. There may be some others out there, but I can't think of what they might be. Yes, sir.
Appreciate your talk here. It seems like the motivation behind half of the country now is social justice. I don't know if that, maybe I'm the only one seeing social justice under every bush anymore, but it seems like the living, breathing document concept of the Constitution. Maybe you could talk about that a little bit. And the whole climate justice. It seems like most of my life growing up, the ACLU was picking off individual Christians here and there with certain lawsuits that, first they started in the schools to kick God, prayer, and the Bible out. And so now we have a country that's very secular, and they're social justice oriented. And it seems like they basically are trying to take away our enumerated rights with unenumerated rights.
Yeah, I would argue that the term social justice is kind of a misnomer because it's often used to justify taking away entitlements from people that people are entitled to by reason of traditional individual justice. In other words, if you earned a certain amount of money and society, through the market, deemed that you are entitled to earn that money, a social justice warrior might say you have to cough up that money even though you earned it, which sounds to me like injustice. But I want to focus on one thing in particular. You mentioned the idea of the living, breathing Constitution, because I think that needs to be addressed. As many of you know, there is a school of thought in this country which, to the effect that the Constitution is mostly a document of generalities, and that we ought to apply those generalities in very broad ways to accomplish the policy goals we want to accomplish, social justice or anything else. And so I'm often asked, do I believe that we have a living Constitution, a Constitution that really is flexible enough to be interpreted in all sorts of ways? And my response is decisive. My response is yes and no. The founders were very, and I made allusion to this in my principal remarks, the founders were very highly skilled legal drafters. In particular, the founders I'm talking about now are the 55 framers. You know, the majority of them had practiced law. They had practiced all kinds of law. They had served in the Confederation Congress. They'd served in their state legislatures. They'd helped to draft their own state constitutions, and they were familiar with a long range of British and English legal documents, and with the colonial charters. So they knew how to draft a provision in a constitution, which is kind of a living constitutional provision. And they also knew how to draft provisions that were very precise. So let's take, for example, a clause. It's in Article 1, Section 9. It's called the suspension clause. And it deals with the writ of habeas corpus. The writ of habeas corpus is one of the guarantees given to us by English law that you won't be imprisoned without due cause. But the writ of habeas corpus can traditionally be suspended in time of war. That is to say, the writ of habeas corpus can be taken away, and people in time of war can be put in prison without trial. So the Constitution addresses this by saying the writ of habeas corpus shall not be suspended except when in cases of invasion or insurrection the public safety may require it. Shall not be suspended except in cases of invasion or insurrection the public safety may require it. That's really loose language. Who decides whether there's an insurrection? Who decides whether there's an invasion? And who decides whether the situation is serious enough that the public safety requires the suspension of habeas corpus? The answer is the courts. So this is a very good example of a provision in the Constitution which is a living type provision. Another example would be the Fourth Amendment, which prohibits unreasonable searches and seizures. This is very much a living Constitution type thing. And the Supreme Court has to deal with it. I mean, the Supreme Court has to deal with such questions as if law enforcement flies a helicopter over a suspected pot yard, right, and films the yard using infrared at night, is that an unreasonable search? Obviously, helicopters didn't exist when the Fourth Amendment was adopted, and probably not too many pot yards, and no infrared lights. So so the U.S. Supreme Court has to use this provision of the Constitution to, in effect, apply an 18th century document to 21st century conditions. On the other hand, there are a lot of provisions of the Constitution that are very specific. The president serves a 4-year term. During the debate over the Constitution in Massachusetts, one of the opponents said, hey, wait a minute. We just discovered the planet Uranus. Uranus has a period around the sun of 86 years. How do we know that the 4-year term won't be interpreted as 4 revolutions? Well, the members of the Massachusetts Convention had fun with that one, but the fact is that's a very, very specific provision, 4 years. Now let me tell you where the dispute really arises. The dispute really arises in parts of the Constitution which were written by the founders to be fairly specific, but which advocates of the living Constitution theory don't really know the meaning of and want to interpret in a very broad way. So, for example, Congress is given the power in the Constitution to, quote, regulate commerce with foreign nations and among the several states and with the Indian tribes. And so a living Constitution person might say, well, what is commerce? I mean, commerce, that could be social commerce, that could be sexual commerce, there could be any kind of business. Well, if you go and you look at the definition of commerce used at the time the Constitution was adopted, it means trade among merchants and certain closely identified activities. And so it is dishonest, in my view, to take a provision like the Commerce Clause and pretend that it applies to all sorts of things that it was never intended to apply to, because it was written to be fairly specific. Some of you may have puzzled over a clause in the Constitution which says, Congress shall have the power to make all laws which shall be necessary and proper for carrying out its other powers. Generations of law professors have said, oh, necessary and proper, what the heck does that mean? That must allow the federal government to do pretty much anything. The answer is no. That language was taken from 18th century documents. It had a very specific meaning, and it allowed the Congress to adopt certain ancillary legislation, not regulate all sorts of things they weren't given the power to regulate. So this is a very long answer, so let me just summarize it this way. The Constitution includes very specific terms that are not designed to have much flexibility in them. The Constitution also contains very flexible terms, like the Fourth Amendment or the Suspension Clause, that are designed to have a great deal of flexibility. And the Constitution has a whole lot of terms in the middle, which are designed to have some flexibility, but not too much. And the living Constitution people generally glom on those kinds of terms and try to stretch them out of all recognition. And so from that standpoint, I don't think what they're doing is correct. Take the microphone if you would.
Aren't presidents kind of bypassing some of that by executive order? I'm thinking of 13583, which is, I think that's Joe Biden's diversity, maybe no, that's Obama's 2011 diversity and inclusivity hiring practice.
Yeah, I'm not familiar with that exactly.
Forcing all government and federal, any employment to hire 12 different kinds of LGBTQ and everything else. But it seems like what's happening too, you're talking about definitions, they're getting pretty sneaky about redefining things, and then they're using that on us, just like the whole definition of insurrection.
Okay, on the issue of executive orders, the president has to be able to run the executive branch, that's his job, and so it's very appropriate for the president to issue executive orders to run the executive branch. In addition to that, the Congress also delegates certain authority to the president and sometimes gives the president authority to issue executive orders. Where things get controversial is when the president goes beyond or appears to go beyond what Congress has permitted him to do. So a great example is when the president had the Occupational Safety and Health Administration issue an order saying that 150 million Americans had to be vaccinated against COVID. They stretched the language of the statute, all out of recognition. Supreme Court, if you recall, struck down the executive order in that case. So whether an executive order is appropriate or not depends upon whether it's for the administration of the executive branch and whether it's authorized by statute. And the Supreme Court has gotten increasingly skeptical about creative interpretations of statute by the president to justify executive orders. Yes, sir.
Question. Kind of looking at.
After him, okay?
So I was just going to ask, you were talking about the constitutional right of habeas corpus, and when it comes to the insurrection clause, there are multiple people who were arrested during the January 6th incident who have not been put to trial yet, and they're still being held in prison without any due process. Is this constitutional if it falls under the insurrection clause?
You know, habeas corpus has not been suspended by Congress, right? But I can't answer the questions as to individual defendants. One of the rules I have, and it's a good one for any lawyer, is not to comment on pending cases based upon newspaper reports. I mean, I read some of the newspaper reports and they're horrific. But I've also been a journalist and I know how inaccurate newspaper reports often are. So if somebody wants to hire me at zillions of dollars an hour to review the cases individually, then I can opine on them. But it seems to me awfully odd that some people are still in confinement, you know. But I honestly can't comment responsibly on individual cases. I'll take one more. Go ahead.
I don't know the exact two cases that are coming up, but it kind of has to do with the different branches and the executive. I think the Supreme Court of the United States is getting ready to look at a couple cases having to do with the executive branch and some of the administrations that are set up and what.
The Chevron doctrine you're thinking of?
Yeah. Wondering if you could just give your thoughts on what they either are projecting they might look at or just kind of the effects of the legislation happening via executive branch authority.
It's a very good question, and I'm going to put it in context, okay? I didn't get to this in my initial presentation, but one of the problems we face today, and it's at the core of the horrendous debt problem we're facing right now, is that in the middle of the 20th century, for a stretch of about 15 years, the U.S. Supreme Court stopped enforcing constitutional restrictions on the federal government. Basically from about 1939, well, actually starting earlier than that, through the 1940s, up until about 1952, if the federal government wanted to do anything, the court would pretty much sign on to it. That's why the Roosevelt administration got away with incarcerating 70,000 Japanese Americans without trial. The court just signed off on it. And during that period of time, essentially the court kind of let the genie out of the bottle, created this undisciplined, unlimited federal spending power and federal regulatory power, which we've been dealing with ever since. One of the things the court did in that era is to say that if you wish to challenge a federal law as unconstitutional, as beyond the power of the federal government, you must prove beyond a reasonable doubt that it's unconstitutional. It's not enough for you to have a better case than the government has. You've got to prove it beyond a reasonable doubt. In 1984, the Supreme Court decided the Chevron case. And the Chevron case extended that principle even further to apply to administrative regulations. The court said if Congress has empowered a bureaucratic agency to do something, and the bureaucratic agency issues a regulation, if there's any doubt about whether that regulation is valid or not, we'll give the benefit of the doubt to the bureaucratic agency. So if you think that a particular federal law is unconstitutional, you got to prove it's unconstitutional beyond a reasonable doubt. And if you think that the agency exceeded its own power, you've got to essentially prove that the agency exceeded its own power beyond a reasonable doubt. The effect of this is to weight the scales against any citizen challenging federal power. There are some members of the Supreme Court today, notably Justice Kavanaugh and Justice Gorsuch, who have expressed great doubts about the wisdom of the Chevron decision. In other words, they've taken the position, look, if an agency wants to justify a regulation, then the agency has to show us why it's constitutional. The citizen shouldn't have to prove that the agency was wrong beyond a reasonable doubt. The agency should be able to explain and justify itself. And there shouldn't be any rule that says that the agency starts off with an advantage or that the citizen starts off with an advantage. It should be treated like any other court case, honestly and fairly. There are many people who believe that the current Supreme Court will in fact get rid of the Chevron doctrine. That is to say, the Supreme Court will say that if there is a doubt about whether a federal agency has authority to do what it did, then we'll decide the issue on the merits. We're not going to give any special preference or advantage to the agency in the lawsuit. That's really what it is you're talking about. This is sometimes phrased in the media as a great challenge to the administrative state. You know, the end of the administrative state. That's not true. The administrative state is going to continue. It's just that the administrative state will have one less advantage in court. Thank you all very much. This has been wonderful. I really appreciate you having me.
Thank you, Rob. Appreciate all your knowledge and information that you shared with us this evening. I believe Betty has a few copies of your book available for purchase, and she will sit out there by the table here if anyone is interested in that. I appreciate, yes.
Yeah, this is a book called The Original Constitution, What It Actually Said and Meant. And these are basically the last 4 copies of that edition that I have. Originally priced at $25, you'll find it on Amazon at $25, but for this crowd exclusively, only $20.
Thank you again. Let's give a hand for Rob. Appreciate you. And that's it, guys. Thank you so much for coming this evening. Appreciate it.